Miss Mooney.
My ladies, my lord, I appear for the appellant together with Miss Hibbert, who sits behind me. My learner from Mr. Norris, Queen's Counsel, together with Miss Crawford, here for the respondent.
Thank you.
My ladies, my lord, this is an appeal concerned with the Animals Act of 1971.
Yes, you can take it, Mr. Mooney, that we have read the judgment and the skeleton arguments.
I'm grateful. I will get through the introduction as fast as I can. We are dealing specifically with subsections 22b and 22c. And in short, it's the appellant's case that the deputy judge was wrong to find that the appellant failed to satisfy the criteria of strict liability under the Act. I'll briefly turn to the facts, if I may, as the judge found them. On the 15th September 2018, the appellant was riding a horse called Tommy at the Beaufort hunt in Badminton. The horse was kept at the respondent's yard, and shortly before trial it was conceded by the respondent that the respondent was the keeper for the purposes of section 2.2 of the Act. The judge found, in the course of his judgment, that the appellant was riding in the course of her employment with the respondent. That was important because it removed the statutory defence under section 5.2, voluntary acceptance of the risk of the 1971 Act. The horse reared, fell over backwards and crushed the appellant. The facts as found by the deputy judge can be found in the call bundle, page 42, paragraph 21.
Thank you.
You'll see there at paragraph 21 that the deputy judge set out his findings in relation to the facts leading up to the accident. How the accident happened as opposed to why is not in dispute. Some 20 or 30 metres after trotting into a field, Tommy suddenly stopped, stepping backwards or sideways, but not going forward. The claimant was encouraging him to move with her legs and through her reins, as well as a light slap on the shoulder of the riding crop. He then reared up to such an extent that he fell over backwards, landing on the claimant. He deals later in his judgment with the why, and he sets out the two alternatives to the why the horse reared up at page 43, paragraph 29. There he sets out, I have been presented with two alternative explanations. First, this was simply an instance of disobedience or napping on the part of Tommy, rearing being a well-known manifestation of this in any horse, and sometimes this can lead to a horse falling over as occurred. The alternative is some sort of catastrophic internal medical event described in layman's terms, though misleadingly, as a heart attack, causing severe pain or at least some awareness on the part of Tommy that something was wrong. And that quote is from the expert veterinary evidence. This led him to panic and rear. He decides in relation to those alternative theories at paragraph 46, page 48. And it's halfway down, or 2/3 of the way down, paragraph 46. In my view, the more probable reason was that Tommy suffered some catastrophic internal, probably cardiovascular failure, which did not cause an immediate collapse, but which was preceded by sufficient pain or discomfort to cause him to stop and then rear. And he repeats or restates that finding at paragraph 76 at page 56, where he says, however, I have found that this was more than simply disobedience for some unknown reason. The horse was probably reacting to a catastrophic internal injury. So those are the facts as the deputy judge found them in his judgment. I turn now, if I may, to the law and the authorities bundle, page 2, please. At page 2 of the authorities bundle, you will find section 2 of the Animals Act laid out in all its glory. You'll see section 2, liability for damage done by dangerous animals. Section 2.1, where any damage is caused by an animal which belongs to a dangerous species, any person who is a keeper of the animal is liable for damage except as otherwise provided by this Act. It is conceded and agreed that horses do not belong to a dangerous species. They're commonly domesticated in these islands, and therefore we go to 2.2. Where damage is caused by an animal which does not belong to a dangerous species, a keeper of the animal is liable for the damage except as otherwise provided by this Act if. And then you have the 3 criteria that's laid out by the Act. Subsection A, as I would describe the dangerous test, that was conceded in this case. You'll see there are 2 limbs to it. The damages of a kind which the animal less restrained was likely to cause, or which, if caused by the animal, was likely to be severe. The concession was made in relation to the second limb on the basis that when a horse rears up and goes over backwards, damage is likely to be severe. We then get into the more contentious elements of the Act, subsection B. Again, this is split into 2 limbs. The likelihood of the damage being severe was due to the characteristics of the animal which are not normally found in animals of the same species. I pause there because that is the first limb. Again, we are not concerned with that first limb. It was not put on behalf of the appellant that this was an unusual horse, one that was prone to rearing for any reason whenever it felt like it. It was a normal horse. So we move on to the second limb. I go back to the start, if I may. The likelihood of the damage or it being severe was due to characteristics of the animal which are not normally so found except at particular times or in...
Sorry, that's not right. Found in animals of the same species. Yes?
Forgive me. I was cutting out that
Well,
section.
that's potentially important. Yes?
The same species are not normally so found at particular times or in particular circumstances. So we have the second limb. What I submit are conditional characteristics. Characteristics that require a trigger to be displayed. And that second limb was the subject to the case of Merver, Heady and Henley, neutral citation 2003, UK HL 16.
As we're looking at the specific wording of 2.2b just for a moment, for everybody's note, am I right in just adding the word not to paragraph 51 of the judgment, penultimate line? Page 49 of the bundle. Doesn't matter, but just to be clear, the judge refers to 2.2b, 2 separate tests. The first class not relied upon here, the second where there is a dangerous characteristic not normally found.
Yes.
Thank you. Yes?
The explanation of that second limb, as decided in the case of Merver, Heady and Henley, is effectively that abnormality is not the test. It is in fact normality. Normality in particular times or particular circumstances. So it's submitted on behalf of the appellant, dogs that bite, horses that kick, cows that trample people. The third criteria, the subsection C, the most straightforward in terms of its wording, those characteristics were known to that keeper or at any time known to a person who at the time had charge of the animal as a keeper's servant. And it goes on to talk about other members of the household below the age of 16. That last characteristic, the knowledge test, is how the respondent puts their case. That is all you need be concerned about. Now, my learned friend put his own case, but as I understand it from his skeleton argument, we submit that you need to understand section 2.2c with reference to what is found in section 2.2b, because what you are looking for in subsection 2.2c is the characteristic that you identified in subsection 2.2b. So having identified the factual findings of the deputy judge, and having looked at the framework of the law that he was working in, because I make it clear this claim was only brought under the 1979 Act. There was no negligence claim. I turn now to what he did find in relation to the law. And page 55, please, paragraph 75 of the judgment. There at paragraph 75, having gone through the various authorities, which we'll come to in a moment, he says this: applying to this case the principles which in my judgment emerge from these authorities, it seems to me that it would not have been enough for the claimant simply to prove that the horse reared and that it's something that horses do from time to time. For example, whether they are startled or in pain or simply being disobedient. If therefore in the claimant's primary case as to what happened, what in fact happened, Tommy napped and reared because he was being disobedient, using that expression not in an anthropomorphic sense, but merely to mean a failure to do what the rider is commanding or expecting the horse to do, that does not satisfy the test in the second limb of subsection 22b. That would amount to a characteristic giving rise to damage, but it would not involve identifying the particular circumstances in which such behaviour is normally found.
Now, Mr. Norris says he would accept liability if the cause of the rearing had been disobedient.
Indeed.
And what do you make of that?
Well, I say that is the crux of this case. I say that when we look at what happened here, the failure by this judge, the error by this judge, is in that paragraph.
So, do you think Mr. Norris is disagreeing with the judge in that paragraph?
Yes, he is. Well, my understanding of his skeleton argument, paragraph 9 of the skeleton argument, appears to be wholly at odds with that, because there's a concession that disobedience would have made out section 22b. In fact, would have made out liability in this case. And that is when we come to it, what we say the crux of this case is. Because what the learned judge did, we submit, is misunderstand what was required for subsection B. In paragraph 75, he identifies various potential triggers for the behaviour, for the characteristic to be displayed. He talks about startled, pain, disobedience, and says this would not be enough. Well, we submit, those are the circumstances. Those are the circumstances giving rise to a rear that satisfy subsection 22b. What the learned judge did was said, I went beyond those what I might call immediate circumstances, and went further and said, no, you need to find more than that to satisfy subsection 22b. What is necessary for a claimant is to find the wider circumstances, or perhaps background.
It's not really the wider, it's the particular. It's the particular circumstance on this occasion.
Well, our submissions, the particular circumstance on this occasion were disobedience, or as he sets out there, disobedience or alarm or pain. They are particular circumstances. He takes it wider to further matters, and I say that's background. The reason that this error, I submit, was made was because the learned, the deputy judge believed there was a tension between the case of Freeman and Hyde Park Farm, Mutual Citation 2008 EWCA Civ 1185, and Lord Justice Etherton's judgment, and the judgment of Lord Justice Jackson in Goldsmith and Patchcott, and Mutual Citation 2012 EWCA Civ 183. And as he set out in the permission to appeal, which is found at the core bundle, page 57, he was under the misapprehension that Lord Justice Jackson had not considered Lord Justice Etherton's judgment, and therefore these two cases were at odds. That is wrong, as he conceded. As he set out, the claimant's counsel pointed out that in the draft version of my judgment sent for parties, I was in error in saying that Jackson, LJ, and Goldsmith had not referred in connection with section 22b the argument based on Etherton's LJ's observation in Freeman. Well, that was wrong as he conceded.
Sorry, where are you reading from?
Sorry, page 57, the permission to
Forgive me,
appeal.
thank you.
And by those, if you want to see the reference to why that was wrong, it's in Goldsmith and Patchcott, which appears at page 86 of the authorities bundle, but the particular reference is paragraphs 53 and 54 on page 95. I should say, while you're getting there, that it is our submission that Freeman is the rogue decision of all these cases, for the reason that at the first instance, there was no expert evidence. So the judge at first instance, Freeman, was able to say, I just don't have any evidence. In that case, it was about a horse bucking, and it bucked the claimant off. I don't have any evidence to say that bucking is a conditional characteristic that would make section 22B, because there's no expert evidence. And that was upheld by Lord Justice Atherton, saying, well, there is no evidence. That is why that is a different case to the other reported cases we'll come to look at. But you'll see there at page 95 of the Goldsmith and Patchcott judgment, where Mr. Brown, the advocate for the respondent in that case, or for the defendant in first instance, relying upon the dictum of LJ and Freeman, submits the phrase at particular times, particular circumstances, denotes times or circumstances which can be described or predicted. Horses do not only buck when startled or alarmed. Therefore, the bucking in this case is not fall within the second limit of section 22B. It refers to the advocate's skeleton argument. And that's exactly the point that this deputy judge, the error this deputy judge fell into, because that's effectively what he was saying in his judgment. And that was rejected by Lord Justice Jackson. Yeah, I do not accept this argument. In light of the authorities set out in Part 5 above, and 22B should be given the restrictive interpretation, should not be given the restricted interpretation Mr. Brown contends. So that is the error that I submit is the crux of this case. And I had imagined that I would be spending much of this appeal, I'd anticipated I'd be arguing about the potential tension between Freeman and Goldsmith, suggesting there is no tension, but if there was, urging you to prefer Goldsmith. However, I don't need to do that because the respondent skeletons we've already discussed concedes this point. Now, if we turn now to page 29 of the core bundle, please. Paragraph 9. This is my learned friend. My learned friend and Ms. Crawford's skeleton argument. On the other hand, if the deputy judge had found the horse reared through disobedience, then if it having been found the defence of Lent did not run, the respondent accepts the claim would have succeeded. This is because both parties know that horses can rear for that reason. We submit, therefore, that all the grounds that relate to 22B are made out. All the grounds of appeal are made out. That concession reveals that paragraph 75 that we've looked at was wrong.
But isn't it a concession made, perhaps realistically, on the basis that it's then put into the context of the facts as found in this case, which is that the horse reared by reason of the internal catastrophic event?
Yes, but I'll come to that because it's my submission that the catastrophic internal event was in fact background information. All that is necessary to find here is what was the horse doing, why did it rear? It reared in the narrow circumstances, the particular circumstances of disobedience.
I'm sorry to cut across my lady, but that's perhaps the issue in this appeal, isn't it?
The disobedience was...
It's the way that one looks at the term disobedience. An event occurred which is a characteristic of disobedience. But in this case, didn't the judge find that the cause of the rearing was a medical rather than an emotional response, if you like.
Yes, but the deputy judge looked at this case in a way where he said, it's not enough for me to find the immediate circumstance. It's not enough to find the horse was disobedient, or the horse was in pain, or the horse was panicking. I need to find something more. And that more that he found was that this horse was having a catastrophic internal medical event. He didn't need to make that finding because there was sufficient to get through section 22B on the basis of this horse was misbehaving.
But no, sorry.
Please.
But as my lady says, that is totally divorced from his findings on the facts. The horse was not being disobedient.
Well, I submit that if you look at his findings, I submit that that's not right. If that is his finding, then he was wrong to make that finding because of the evidence he had.
You've taken us very helpfully to those express parts of the judgment where the judge says the cause of this incident was a catastrophic internal injury. That caused the horse to rear.
But he only had to find that because he'd erroneously decided that the narrow circumstances were not enough.
But doesn't that just beg the whole question of what is required for section 22B and C, as my lady says? So put 75 to one side, and we'll have to hear from Mr. Norris as to how he squares that paragraph with his concession. But it doesn't necessarily, to my thinking at the moment, answer the fundamental questions of principle as to what is required for 2B and C.
Well, may I deal with that now?
Is that what you... Yeah.
Well, when we look at section 22B and what the judge found, it's my submission that the rather opposed positions that my learned friend sets out that he gave an argument that on one hand you need to find some sort of foreseeability to get through 22C, or on our account that we're taking the content out of 22C. Those arguments I will deal with in a moment, but on the narrow issue of 22B, if we look at the judgment, what the judge actually found. Well, if you look at paragraph 21 again of that judgment, page 70, forgive me. Page 42 of these are his factual findings. How the accident happened as opposed to why is not in dispute. And he goes on, Tommy suddenly stopped, stepping back or sideways, but not going forward. The claimant was encouraging him to move on with her legs and through the reins, as well as a light slap on the shoulder with a riding crop. He then reared up. That's the extent that he fell over backwards, landing on top. He is describing something before the rear. He is describing disobedience. The horse stopped.
He doesn't say that, does he, Mr. Mooney? Because he says how the accident happened as opposed to why. So he gives the factual narrative of what occurred which led to the injuries to the claimant.
But within those findings are something more than a rear. They are the horse not doing as it's told. The claimant was encouraging him to move forward with the legs through the reins. The horse wasn't doing it. That is disobedience. And we turn to 70.
Well, that's your interpretation.
Yeah, and if you look at paragraph 29, he says, well, why did this happen? Was it disobedience? Or was it the catastrophic medical event? I mean, isn't that the judge saying, I've got to weigh up the two?
Well, yes, but I say this all goes back to his error, that what he is doing here is saying the mere disobedience is not enough. Therefore, I've got to find something more.
No, he's saying the mere narrative of how it happened is not enough. I've got to find out why, which goes back exactly to what my lady was positing just a moment ago and discussing with you. It's not enough just to say, there's the narrative, move on. He was right, he's got to get to the bottom of it. And we have to bear in mind, don't we, Mr. Mooney, that the way that you put your case below was rather any which way it falls, I'm the winner.
Yes.
So you go either it's A, B or C, and in any of those cases, it all amounts to disobedience. But that's the narrative, that's not the wherefore.
Well, let me have one more go on the disobedience point, if I may. At paragraph 75, he describes This is page 55.
Right. So he specifically distances himself from the anthropomorphic sense of disobedience.
Indeed. So he says, for example, when they're startled or in pain or simply disobedient, if therefore in the claimant's primary case what in fact happened, Tommy napped or realised he was being disobedient, using that expression not in an anthropomorphic sense, but merely meaning a failure to do what the rider is commanding. So that is his definition.
He says that's not enough, and that's entirely consistent with the authorities, because in each of the authorities where Section 2 liability is made out under this second limb, there was something more. There was a finding, both as to fact and knowledge, that there was something, we don't necessarily know what, that spooked the horse. So it's never mere disobedience in the anthropomorphic sense identified by the judge there. There needs to be something more. Now, we'll hear from Mr. Norris as to quite how far his concession goes. But mere disobedience, is there any authority, and it may be that I've missed it certainly, is there any authority where mere disobedience with no outside factor at all has been held sufficient for the purposes of Section 2.2b second limb?
Well, the closest, my lady, the closest you'll get is Goldsmith and Patchcott,
Right.
where it's mere startling led to rearing and
Something
bucking.
startled the horse. So again, there is something external that startles the
Well,
horse.
my lady, this will come to a different submission I'll make, which is this. I'll make it now. When you look at Section 2.2b, what does it require you to find? It requires you to find a conditional characteristic. So when we look again at subsection 2.2b, the likelihood of damage being severe was due to characteristics of the animal which are not normally found in animals of the same species, or are not normally so found at particular times or in particular circumstances. That is, as I submitted at the outset, looking for a conditional characteristic. What is a conditional characteristic? A conditional characteristic is something that requires a trigger, a characteristic that needs something to trigger it. Now, how do you prove that? Do you need to prove that there was a particular characteristic that required a trigger, or do you need to prove that and also the particular trigger that triggered the characteristic? Now, I submit, on its true reading of subsection 2.2b, you only need to find a conditional characteristic. So, for example, if an expert, and are usually experts in these characteristic cases because you need an animals expert to deal with what characteristics animals have, says rearing is a characteristic in horses that they only display at particular times or in particular circumstances. They're all capable of it, but they require a trigger. There may be a number of different triggers out there that will be required for a horse to rear, but we know it's a conditional characteristic. I submit that evidence is enough to satisfy subsection 2.2b.
So if you're right, the horse here has the conditional characteristic of rearing upon catastrophic internal injury. It rears not because it has a catastrophic internal injury, or indeed because it's being disobedient. It rears because it's got an itch. On your analysis, liability under section 2.2 arises because the cause is irrelevant. The trigger is irrelevant. The conditional characteristic exists, but provided it's rearing, it doesn't matter whether one of the triggers actually took place or not.
No, I submit a trigger has to take place.
Right, so you have to identify the trigger.
No, you don't have to identify it, you have to know that it can only be triggered by a particular circumstance.
Right, but if you must be saying you need to know if the trigger's taken place.
No, if the evidence is this is a conditional characteristic,
Yep.
biting in dogs, for example, rearing in horses, as in this case, if you know that that characteristic is only triggered in certain particular circumstances, we can't read animals' minds, so we don't know whether it was fear or whether it was pain or whether it was something else. All we need to know, I submit, is that one of those triggers must have been present, otherwise the horse wouldn't have done it. Once you've established that a characteristic is conditional, it follows that when the animal displays that characteristic, one of those triggers must have existed, even if to the human eye it's not clear what it was.
So what's the purpose of subparagraph C then?
Well, that is, of course, the difficulty with Mervahidi. Once Mervahidi had
Well, I'm
rather...
asking you what the purpose is.
Well,
On
since
the basis of your submission.
Well, the purpose of subsection C would still it still arises in relation to an animal that was unusually dangerous. So if you were to purchase a dog which you had been told by the vendor was a particularly well-behaved dog, and you got it home and at the postman, you would be able to say, I had no idea this was a dangerous dog. I didn't realise it had this characteristic. Therefore, I'm not liable. So section...
Well, shall we stick to horses and rearing?
All right,
Which, as you say, could be anything from a fly biting it to a catastrophic heart attack.
Yes.
I mean, what would be the purpose of subparagraph C in such a condition? Because if you say you only know that there needs to be a trigger for the horse to rear, there's always got to be a trigger unless this horse likes being a circus horse and thinks that that's its job. I mean, what would be the purpose of paragraph C? It would mean that as soon as you'd got past A, in fact, it's tick, 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 liability, move on to damages.
Well, my submission is there will still be times when section 22C will apply, as examples I've given. If it is a horse is a habitual rearer, and you didn't realise that, and you only had it a short period of time, you'd never seen it rear, that would escape liability.
Then go back to subparagraph B and say, but horses rear. Any horse rears in certain circumstances, in particular circumstances. So on that basis, why not say right from the start that we're in subsection 1 territory? Just say that a rearing horse is a dangerous beast.
Well, this goes back to the effect of Mervahidi, and I submit this is the danger of where the defendant's submissions get you. It's an attempt to use 22C to circumvent that claimant-friendly judgment that way of Mervahidi, because once Mervahidi is established that section 22B is very easy to make out, and the authorities are clear. It's
once subparagraph A has been established. That's what they say. They don't dismiss subparagraph C, however, do they?
But if you've emptied section 22B of content, or largely emptied the content, it follows that the paragraph that requires you to know the characteristic of 22B is itself going to be much less effective.
I had missed Mervahidi. Where does it say that section 22B is? I mean, I've not missed Mervahidi, but I've missed the bit in Mervahidi which says section 22B is easy to satisfy.
Paragraph 43 in the authorities bundle. There's a discussion in Lord Justice Nichols' judgment, paragraph 43. Page 23 of the authorities bundle.
If the tendency of a horse to bolt when sufficiently alarmed is to be regarded as a normal characteristic in particular circumstances, and hence a horse with this characteristic will meet requirement B, it's not easy to conceive of circumstances where dangerous behaviour will not satisfy requirement B. But there you have, first, the bolting, and secondly, the trigger.
Sufficiently alarmed.
Yes, so you have...
And I submit you could superimpose this case. In other words, the tendency for a horse to rear when sufficiently disobedient or alarmed is regarded as normal characteristic in horses in particular circumstances, and hence the horse with this characteristic will meet requirement B. I submit you can superimpose that. And I go back to the point which I know that your lady wasn't particularly impressed with, is my submission that when you narrow down what you need to prove for section 22B, you don't need to look at what I've called the background of the wider circumstances. You don't need to find the reason. Mervahidi itself was a case where nobody knew why the horses had bolted.
No, but they knew they'd been spooked.
Well, the suggestion was they must have been, because that's why they panicked.
Yeah.
But that's as far as it went. We don't know why they bolted. We just know that they must have done, because, and that goes back to my submission, that once you know the characteristic has been triggered, it's then just supposition as to why it's been triggered. But it must be one of those triggers.
But when you've got a situation whereby, as in this case, the defendant in the court below, but the respondent in this case, says, well, we do know why this horse reared. And it was because, as the judge found on the balance of probabilities, of a catastrophic internal event, the knowledge of which could not reasonably be held by this respondent.
My submission on that point is this. If it is right that that reasoning has to be found, then you are putting a claimant at a disadvantage where there is, in effect, more information. So we look at Mervahidi. We don't know what triggered those animals to bolt. We just know something must have frightened them. We look at Goldsmith and Patchcott. We don't know what made that horse buck and rear. We just assume it was alarmed. We look at Welsh and Stokes. That's a neutral citation, 2007, EWCA, Civ 796. And Lord Justice Dyson's, he then was his judgment, where we know a horse reared when not wanting to go forward, but we don't know why it didn't want to go forward. So in all of those cases, a claimant has been successful by lack of knowledge. It is entirely, in my respectful submission, unfair and contrary to principle. So because you have more background knowledge, a claimant then fails.
If you're right, doesn't it mean that the keeper of any horse that rears, in practical terms, is strictly liable for any damage caused by the rear?
Well, you've got to get through 2-2A first.
Yes, I assume you're through 2-2A, which you're going to be with rearing because that's common ground.
Well, not necessarily. It was conceded in this case, but there's over to comments in the case of Turnbull and Warren that suggest actually you need to look more carefully at section 2-2A.
So let's assume 2-2A is through. You get through 2-2A, then the keeper of any horse that rears is strictly liable. And you may say that's what the Act intended.
Whether it's what the Act intended or not, it is what has become the law since Mervahidi, in my submission. The emptying of 2-2B of content necessarily leads to the emptying of 2-2C of content, and therefore that is right, that you are left with effectively a much stricter liability.
If you're right, Mr. Mooney, looking at a dog, for example, dogs are known to bite, and whereas normally a dog will not bite, save in particular circumstances, protecting their litter, having their territory threatened or whatever, guarding their owner. If this dog bites, there must have been a cause.
Yes.
So any domestic animal acting uncharacteristically, whether by species or by its own personality, the owner is liable. That's what you're saying.
When a conditional characteristic that is dangerous is exhibited, yes, that's right. And that is the effect of Mervahidi, and that is why Mervahidi was so controversial. But that is what we are left with, because as been set out, we've looked at Mervahidi itself and the lack of content. It's made clear by Lord Justice Jackson in Goldsmith, and it's made clear again in Turnbull by Lord Justice Morris Kay, just how empty 2-2B is now of content.
Well, that's why we've got to look at 2-2C, presumably.
Well, no, because if your characteristic is so easily made out, then knowledge of that characteristic will necessarily be equally made out.
But that suggests that 2-2C was intended to create the very thing that you're saying is unfair to the claimant in this case, an investigation into what caused that characteristic to demonstrate itself in the particular case, in the particular facts that are before the court. Why have 2-2C at all?
Well, why draft 22B as it was drafted to cause the confusion that it was
Well, why
drafted?
not have 22B saying, unless the owner of the domestic animal is without capacity and therefore understanding, any injury caused by an animal resulting in injury which is likely, when caused, to be severe, is liable. I mean, the Law Commission inserted subparagraph C to cater for these very arguments, didn't it? There was an outcry that the strict liability that was imposed was a free pass for those injured by animals that were not otherwise considered dangerous.
Well, forgive me if I don't use the free pass, but certainly since Mervahidi, it has effectively...
Shall we examine that then? Because you keep saying this, but shall we examine exactly what it says?
Well, yes, can I first of all, if I may, take you to the Law Commission and it's paragraph 42 of the Goldsmith judgment. It's elsewhere, but I have a look at that page.
Yeah.
Page
So,
93.
93. Okay. And did you say it's 42, yes?
Paragraph 42.
Yeah, thank you.
And this is from Lord Justice Jackson's judgment. The mischief against which Section 2.2 of the Animals Act is directed can be gathered from the report of the Law Commission on Civil Liability for Animals, number 13 of 1967, which preceded the enactment of the Animals Act. At paragraph 17, the Law Commission wrote, if, as we have recommended, there is to be a category of animals of a dangerous species for which strict liability is imposed, it would seem reasonable that an animal not belonging to that category should nevertheless give rise to strict liability in respect of injury or damage which it causes if the damage results from dangerous characteristics of the particular animal which are known to its keeper. Now, I concede that there's
That begs the question.
I can see there's a lot more of that paragraph to go, which I'll come to. But just on that, up to that part of the paragraph, what is the dangerous characteristic in this case? It's rearing.
Well, that's your position. The counter position would be that means rearing in the particular times or circumstances.
And can we just see that it's particular animal that the Law Commission is talking about, not particular species, as my lady pointed out in terms of the actual statute?
Well, the category of animals of a dangerous species is set out there in the
Yes.
law.
Of the particular animal which are known to its keeper.
Indeed.
It's the particular animal. It's Tommy in this case, rather than a horse.
Well, in relation to subsection 2.2c and the knowledge,
Yeah, I'm talking about this paragraph.
yes,
Yeah.
yes. But of course, in relation to section 2.2c and the knowledge, the knowledge suffices to be the general knowledge of horses in general.
Well, we'll be coming to that, I've got no doubt.
So I submit that when you look at what the Law Commission's aiming at, dangerous characteristic, in this case is rearing, does the respondent know his horse rears? Yes, he does. Of course, whilst the suggestion is being made that effectively section 2.2 has lost meaning, or section 2.2c adds little now, it must be remembered that in most cases there are still the statutory defences under section 5. This case is different because it's an employer-employee relationship. So it is not as though the Animals Act now is, to use the phrase free pass, because in most cases, most horse riding cases, the rider will be a volunteer and will fall foul of section 5.2. And that was seen in Freeman and in Turnbull and other cases.
Right, when I said free pass, I didn't have reference to the statutory defences. I think I was rather referring to the thing that we will have to come on to, which is paragraph 43, judgment in Goldsmith, which seems to suggest that paragraph C, subparagraph C, achieves that which the Law Commission set out to achieve, that is, a wolf in sheep's clothing. the particular Tommy, was Tommy a wolf in sheep's clothing? Or was he a poor unfortunate beast who, on this particular occasion, had a heart attack, or one of the other suggestions was a whiplash injury that caused effectively damage to the brain. But there we go.
Of course, the deputies didn't find that second outcome, and that second outcome would have happened after he'd reared up. So that would have been perhaps an easier case for me to make out had he found that the whiplash was the cause of the
whiplash. Yes, that would have been a trigger plus then consequence.
Save that in those circumstances, all that I was submitting was that disobedience was enough. And the disobedience is not anthropological, it is anthropomorphic. It was simply disobedience, he wasn't doing as he was told.
No, I think, doesn't it come to this, Mr. Mooney? I mean, you would have to say, and we'll take the whiplash, this horse was disobedient. That was the trigger. It then led to the horse rearing, which then led to the whiplash injury.
Yes.
So you've got the trigger, which is the disobedience.
Yes.
In this case, however, you can't say the horse was disobedient and that led to a heart attack.
No, but I can say the heart attack led to disobedience.
Well, then it's the heart attack that's the trigger. And that's when paragraph C comes in, surely.
Well, but I say that's not right, because effectively you are saying because you know that information, a defendant is in a better position. The defendant has no idea why the horse did something. So
well, yes, but there's something like constructive knowledge here, isn't there? If you say, well, it is simply not permissible for a respondent to say, I close my eyes, I close my ears, I close my mind to the possibility of what caused this horse to rear, and therefore you cannot establish subparagraph C, or we know on the balance of probabilities what causes horse to rear, and therefore I am not willfully disregarding disobedience. We are saying that did not apply in this case. You've got to have fair play for the respondent or the defendant as well, you know. It's not just as I say, a free pass for the claimant.
But willful or otherwise is not relevant here, because we can't anthropomorphise the animal. What we're saying here is this horse displayed disobedience. Now,
that's what you keep saying. That's not what the judge said.
Didn't I submit disobedience. He was reacting. He was reacting to what was going on. He wasn't being naughty.
Well, being naughty in my submission is dangerous territory, because then you're getting into territory of effectively finding mens rea for an animal's behaviour.
No, okay, well. So you say disobedience means literally not doing what the rider is telling you to do.
Indeed, and that's what the judge found at paragraph 75.
Do you know what? You've then got to go back, haven't you, to subparagraph A, because it refers to if not restrained.
Yes.
And in the circumstances of this case, how can you restrain a horse from having a heart attack?
You can restrain the horse from rearing, whether it's having a heart attack or not.
Well, could you? That's what the judge wasn't very satisfied about. I mean, how do you stop a horse rearing if it's having a heart attack? You'll know better than most, Mr. Vicar.
Well,
I'm not asking you to give evidence. That was perhaps a cheap shot.
Well, the submission that I come back to is that it's if you say there is no mens rea behind animal behaviour, and you look at disobedience, and the way this, in fairness, the deputy judge did, and just say not doing as it's told, there is evidence that this judge found this horse was not doing as it was told. I accept the point, well, I take the point that the argument is, well, the trigger for that not doing as it was told was some sort of internal injury. I submit that is a stage back from what you need to discover. And I come down to this. When we look at Welsh and Stokes, a case where a horse reared because it didn't want to go forward, and it had a rider that wasn't very brave on it, as the circumstances. I submit that if you find in that case a horse rears because it didn't want to go forward for an unknown reason, and that satisfies the act, why I ask rhetorically, in our case, when a horse doesn't want to go forward, does it not satisfy the act just because we know the reason why it doesn't want to go forward?
Do you want to take us to that authority?
Welsh and Stokes, it's page 54.
Thank you.
Now, the relevant, there's a long section on hearsay evidence at the beginning, so we have to get quite into judgment. Page 65, please. Because Welsh and Stokes really is the only authority on section 22C. It's the only that's mentioned in other cases, but this is the case that really deals with section 22C. Page 65, paragraph 32. This is where the Court of Appeal deal with what the first instance judge found. And he goes through it in paragraph 55 of the first instance judgment. Over the page to page 56, to paragraph 56 of the original judgment, still on page 30, paragraph 32 of this judgment, I've come to the conclusion, this is the first instance judge's decision, I've come to the conclusion that the defendants, as experienced keepers of horses, would have known that Ivor, like any horse of his kind, was capable of rearing in certain situations if not handled properly. Now, let me...
This is the if not restrained point, if not handled properly.
Yes.
Yeah.
But I accept that's the first instance judgment rather than the Court of Appeal judgment. But that is as close as you get to my formulation. Capable of rearing in certain situations if not handled properly.
So does the Court of Appeal deal with this point then?
Court of Appeal then moves on to look at this in paragraph 70, 71. This is page 74. It is not in dispute that subsection 2C requires it to be shown that the keeper knew that the particular animal which caused the damage had the characteristics found to satisfy subsection 2B. The only question is how...
my fault. What paragraph?
But forgive me, my lady.
It's my fault.
It's paragraph 70.
Thank you very much. Thank you. Yes.
The only question is how that knowledge can be proved. And the argument in this case is whether you had to have had knowledge of the actual horse. So in our case, did we know Tommy might rear? In this case, it was Ivor. Did we know Ivor might rear? Ivor had never reared before. And it was submitted in that case that you could only prove it if the keeper knew that the particular animal had previously behaved in that way.
This is the important point that one of the points Mr. Norris makes, which is that it's knowledge of the species, not knowledge of the particular animal. That's this paragraph.
Yes.
It doesn't address my lady's point about the point at paragraph 56 of the 56 of the judgment below isn't followed up.
Well, we'll save to say that paragraph 71 does go wider than the formulation I've just given you.
Mm-hmm.
Well, isn't this is dealing with the submission made in that case that the knowledge can only be proved by showing that the keeper knew that the particular animal had previously behaved in that way.
Yes.
Now, in this case, there's no suggestion that Tommy had ever had a heart attack before. So, unsurprisingly, Lord Justice Dyson, as he then was, said, "I do not agree." And that's how we've got to read paragraph 71 in the context of paragraph 70. And we also need, don't we, to go back to paragraph 59, where the criticisms of the findings of the judge are examined. Particularly striking was the evidence of Mr. Macur that it was very common for horses to rear if ridden by a person who does not allow the horse to run away from the source of fear, but insists on riding forwards. And his reference to rearing in the particular circumstances being within the parameters of normal equine behaviour. I also refer to his statement that rearing is within the range of a horse's natural behaviour. behaviour. And then goes on to look at either in this case rather than Tommy. The relevant question is whether rearing was a characteristic normally found in horses as a species, and this is my lady's point and the respondent's point, in the particular circumstances. Either perhaps had never been exposed to the particular circumstances so that his response to them had never been tested. The relevant question was not whether Ivor tended to rear generally, but whether he had the characteristics of rearing in the particular circumstances. I do not accept that the judge made inconsistent findings. Isn't that exactly our case?
Save that the particular circumstances in that case were unknown. All that was known was he didn't want to go forward for some reason. Now, and that is the point that I make, which is, well, if that's good enough in that case, the fact that you might have information that allows you to look into the background, if the deputy judge was right in this case, had Ivor had a heart attack, then this case wouldn't have been made out. But we don't know why Ivor didn't want to go forward. So the fact that
but if you do happen to know, then you've got to be dealt with on those facts.
But,
and why is it unfair? Why is it fair, even under in a strict liability context, for the respondent here to be liable if the particular characteristic, namely rearing because of internal injury, was not one known to him? Because we know that subsection C imports a requirement of knowledge. If you're balancing the interests, what's unfair about that, where you do know what happened?
because if you say you need to know, effectively going backwards in time to the background, you end up in a situation where defendants will argue, well, I didn't know that this horse was going to, I didn't know there was going to be a loud bang in the field that day. I didn't know, and you go backwards and backwards and backwards. At this stage, on the authorities we have...
No, that's not, the test here, forgive me, wasn't did he know he was going to have a heart attack. The question is, did he know if, upon a heart attack, the horse would rear? That's the relevant knowledge, not the knowledge of the bang.
To take your loud bang, did he know that if there is a loud bang, the horse will rear?
Well, then we come...
As in, whichever case it was, where they all bolted, never heeded, wasn't it? I mean, nobody knows why they did. Something obviously startled or shocked or whatever them. So the assumption, it turned into a finding of fact, that's what happened. In your example, loud bang, horse rears. What the keeper has to know is that if you have a loud bang, the horse will rear. But here we know that the horse had a heart attack, and that's why it reared. I say we know, that's the finding of fact. And so why is the question not, amongst other things, did the keeper know that if a horse has a heart attack, it will rear?
Well, we go back to the point I accept I've been struggling with, that you don't need that precision of knowledge. It is enough to say, I know my horse will rear in particular circumstances. I know rearing horses, and that is all you need to get through section 22B. Now, if I'm right about that, it's all you need to know in section 22C as well, that horses rear when they're sufficiently triggered to do so.
So do you accept that whatever position is reached on 2B is that's its knowledge of that?
Yes.
So the two to be read together?
Yes.
Yes, thank you very much.
Yes, I can't change horses, as it were, after we get through 22B.
Very good.
But that's where we get to in relation to 22C. It has been rather... The effect of it has been narrowed as a result of the maneuver he defines in section 22B, because I do submit that all is needed to find is that a characteristic is that it's a conditional characteristic, and that is sufficient. And that gives the Act its normal English meaning of section 22B. May I take you for a moment, if I may, to my learned friend Skeleton, page 29, page 30.
Which paragraph?
Paragraph 13 onwards, please. This is where he sets out what he describes as, or as what my learned friends describe as the battleground. Talks about settled principles of rearing or bucking as a characteristic. Keeper can only have knowledge of the characteristics of the species rather than a particular animal in question, and such knowledge being actual, and he looks at Welsh. He then goes on to
so do you want us to go back to 12?
Sorry, forgive me, my lady. I was setting some background before we go on to 13. These are settled principles, he says, and then he goes on in paragraph 14. Paragraph 13. If it follows the appellant's argument on appeal amounts to no more than arguing that the appellant was injured because the horse reared, rearing as a characteristic, whatever the cause, both parties knew the horse's rear, ergo all three elements of section 2.2 are satisfied. And that is
And
the
is that
criticism.
correct? Is that what you're saying?
Save to the extent that I say where he says the appellant was injured because the horse reared, reared is a characteristic, whatever the cause. I say rearing is a conditional characteristic.
Right, so that's the only thing you'd put in.
That is the only problem I have with his characterisation in my case.
Right.
He goes on with the criticism that my ladies and my lord have been making of my approach, which it deprives 2.2c of any real meaning. And I submit in relation to that, well, that is because the Act is driving at finding out if an animal is dangerous by virtue of its characteristic. The dangerous characteristic here is rearing, so it is sufficient to know your horse rears. And then he goes on to look
But you say every horse rears in certain circumstances.
Yes.
Isn't that the point?
Yes.
So conditional characteristic is that a horse will rear in certain situations.
Well, that is the evidence
Every
in this case.
horse. No, that's what you're saying, that the evidence is that every horse will rear. Every horse, because it belongs to a species with this characteristic.
Yes, that's the evidence in this case. That's what the expert said. Rearing is a conditional characteristic.
Well, conditional on a trigger,
Yes.
not conditional on a personality of the animal concerned.
Well, if it was conditional on the personality, it would be the first of the 2.2b, because it would be an unusually
Yes.
animal prone to rearing.
So this is your 2.2b
Second.
2.
He then goes on to take the example of the dog, and I submit he's exactly right. That example in paragraph 15 is exactly how the Animals Act works now. A dog may well cause severe harm. Dogs bite, it's a characteristic, because all dogs will bite in particular circumstances, if that's the evidence of your case. And dog owners of species, dog owners know dogs of species bite. He then goes on in paragraph 16 to set out what he calls the correct approach. Unless the defendant has some awareness what might cause a docile dog to bite, and the dog bites in such circumstances, is able to rely on section 2.2c. The classic example would be a bitch with pups, which it feels the need to defend against, for example, an over-inquisitive toddler. The claimant succeeds only if the defendant knows the bitch has pups, and knows or ought to know, as any dog owner would, that it may be aggressive defence if it feels threatened. In my submission, that counter approach, as unattractive as my ladies and my lord may have found my approach, that counter approach, I submit, is more unattractive, because rather than emptying section 2.2c of content, it empties the entire act of content, because effectively it's negligence that is being suggested there. If a dog owner knows his dog will be aggressive when it has pups, and he knows it has pups, and he knows there's an over-inquisitive toddler there, he has a duty to protect that over-inquisitive toddler. And in failing to do so, he would be negligent. So my submission is that paragraph 16 rather...
Well, ought to know, with respect to Mr. Norris, must be wrong. Because that's not in the Act.
No. But what I submit is that paragraph illustrates the dangers of looking at this the other way. You effectively take out any content of the act. It becomes negligence. If you make 2.2c, you beef it up too much, as my learned friend suggests.
Well, that's because both of you are taking extremes with respect, and a lot of these cases, if they are extreme, will dictate their own answers. But can you contemplate any situation, Mr. Mooney, I'm asking you to argue against yourself for this purpose, of a horse rearing which will not incur strict liability for its owner or keeper?
Yes, if it's a habitual rearer that the keeper doesn't know is a habitual rearer.
Well, if it's habitual, that rather suggests that the keeper does know.
Well, if the keeper's only had it for a short period of time. I'll go back to my, if you purchase a horse from a dealer who tells you it's a very nicely behaved horse.
Okay. So taking it into Tommy's case then, if this particular keeper, Mr. Seymour-Williams, says, well, you know, I'm taking this horse really in order to get the services of Miss Ford, because it's, you know, no skin off my nose, and in fact I'll get some benefit, but I don't know Tommy from, you know, the next horse, and I don't know that is anything other than a horse that will do its best. It's been bought as a hunter by its owner, even though its owner is a polo player. Right, so there we go, and all of a sudden he has a heart attack. So there's been no vets saying, oh, we've got to be very careful of this horse. All of a sudden, what's the difference between that and a horse that's only been kept for 2 minutes and all of a sudden rears? On the basis that even though a horse can rear in certain circumstances, you're saying, well, the keeper wouldn't know about it and therefore can claim subparagraph C. That does make subparagraph B a nonsense with respect on your argument, because it's a characteristic of a horse to rear in certain circumstances, including disobedience.
No, but if there is a distinction between the first limb, the horse that is unusual because it behaves so unusually, because it has this particular characteristic that rears up with everybody all the time. That is a different category to the horse that is normal, but only rears up when triggered to do so.
But the example with two, when I asked you to argue against yourself, you said yes, you could have some horse that is an habitual rearer, and effectively the purchaser has taken without notice of that. And within a week, he rears, the horse rears, injuries are caused, and you say there's still a defence because the keeper would not know of that characteristic.
Yes.
Even if the rearing would have caused any horse, that the incident would have caused any horse to rear.
Oh, that might be different in those circumstances.
Well, that's actually what you said. You said that a rearing horse could still not trigger the strict liability if the keeper didn't know about it. But if keepers have knowledge that horses will rear in certain circumstances, where do we go?
But sorry,
If, as you say, and the argument has been so far, horses have a characteristic of rearing in certain circumstances, but you concede that there will be circumstances, nevertheless, where the horse's owner or keeper can escape strict liability because they've only just purchased the horse and had no knowledge of that characteristic. I'm asking, you know, where your sense of fair play is.
Well, the particular examples we've looked at will depend on the evidence of the case.
Right.
And if the experts say this is not, this rear hasn't been triggered by anything, I can tell you that by looking at what's happened in the circumstances. There's no normal trigger. It's
Right.
just a horse that loves standing on its back legs. Now, that would be a different set of circumstances. And that would be a case where a keeper could say, well, I had no idea that this horse just reared up for no good reason
So
all the
the
time.
facts have established that there's no good reason for the horse to stand on its hind legs. It goes back to the fact-specific findings of fact.
Well, yes, and I'll have one more go, if I may, at the findings of fact before I leave this point alone. I appreciate it.
Just before you do, this habitual rearing horse likes going up on its back legs. Presumably, people who ride horses would rather horses didn't do that. And presumably, they would do everything they possibly could to stop them doing that, including this habitual rearer. And so if the horse did it, it would be disobedient, wouldn't it?
Well, my lady asked for an example as I was on my feet, and I've given one, and if it's now being used to trap me, I see the
I'm not seeking to trap you. I'm simply saying you say that a horse will rear. It might rear because it's disobedient. It might rear because it's been startled. In this case, so the judge found it reared because it had had some catastrophic internal injury. Straight away, I really know nothing at all about horses. Doubtless there are other reasons why they will rear. But these are all triggers for horses rearing. And your submission is, all you've got to prove is the characteristic, not the trigger. That's right.
Yes.
Yeah.
But if your evidence is this is not a normal horse, this is an abnormal horse, then it takes it out of that second limb, and therefore you're not looking for the particularity anymore. You're saying, it doesn't matter about particularity anymore, it's a dangerous horse. It's section 22B, first limb. It is an unusual animal. You're only looking for that particularity, that conditionality, the trigger that I've talked about, if you're into second limb territory. And you're not if your evidence is this is an unusual horse that rears all the time.
So isn't that what the judge found? This is an unusual horse in that he had a heart attack?
No, he found he was a normal horse. He looked at the section of section 22B, and he found that, we've looked at what he found, but he found that the trigger, as he said, was some sort of internal injury. Where I have criticised him is that actually, on the evidence that he found that period of time before the rear where the horse was on any basis being disobedient and it wasn't behaving as it was asked to by its rider. And I said I'd have one last go. Can I ask you to turn now?
I did not identify in your grounds of appeal or skeleton argument this argument that actually you say this is a case of disobedience, which is, as I understand your submission now. Is that, if I missed something?
Well, what I submit in my skeleton argument in relation to my grounds of appeal, I deal with subsection 22B.
Yes.
And I submit, and what I say here is, in ground 2, learn to wrongly distinguish the findings in relation to subsection 22B in the case of Murder-Heedy and the rest of them.
Yes.
And what I say about that is because I say in those cases you have an immediate trigger and then you have wider background. And what I criticise the judge for in this case is looking at wider background rather than immediate trigger.
But there's no, I don't mean this disrespectfully, but is this a reaction by you to Mr. Norris's concession?
Well,
is this submission a reaction by you to Mr. Norris's concession that disobedience will do?
Well, it places everything in focus, that concession. I hadn't expect that concession when I drafted the grounds of appeal in the skeleton argument.
Right.
And so that concession then rather narrows my grounds of appeal because the section 22B argument appears to be over in that just the mere disobedience is enough.
Yeah, I don't think this court in any way seeks to deter people from making realistic concessions as the case develops, as the appreciation of the law and its applicability develops, because that does help. And certainly it helps a court where parties are not feeling so constrained to take the extreme position and to make no concessions that they get no assistance. I mean, we are looking for assistance. So if there is this concession, disobedience would be sufficient if that was the cause of the rearing to lead to the strict liability imposed to A, B, and C. That's fine, but you're then trying to get it round, as my lady, I think, is saying, to the issue of disobedience, and saying, oh, well, it's because the judge went wider, or went to the circumstances that caused the disobedience that I'm really complaining. Because if you can identify what caused the disobedience, it's got to be relevant, hasn't it, Mr. Mooney? Especially when the circumstances in this case are quite extreme.
Well, I don't say it's not relevant. What I do say, well, I perhaps do go as far as it's not relevant, but what I do say is that if you don't need it in the other cases, if a lack of knowledge gets you through the gate.
I understand. But in fact, just to be fair, we will, of course, get to Mr. Norris, but he's making a very careful concession, and I don't think it's the one that you're identifying. He's saying if the judge had found that the horse reared through disobedience,
yes, I accept
the
that.
judge clearly did not find that the rear, whatever happened in the period when he was napping, he did not find that the horse reared through disobedience, as my lord has pointed out. He clearly found the opposite. He rejected that case. So it's not just saying mere disobedience is enough. Mr. Norris's position, it would have to be that the cause of the rear was disobedience, and that he suggests was not the finding.
Well, you have my submissions on that, and they won't get better for repetition, but I do submit that if you read his factual findings, they lead to a conclusion that he did find disobedience. But if he didn't, I submit that he was wrong in not finding disobedience. And I submit that on the basis of the agreed evidence he was presented with by the experts. I needn't take you to the various question expert reports, because I've summarised it in my skeleton argument at page 17.
But where do you
get
summarise it?
Paragraph 14, page 17 and 18.
Where do you find rearing through disobedience?
Well, I take that from the respondent's expert, Anne-Marie Taylor, and that's over on page 18. She said this: the behavioural characteristic that caused the damage was the horse rearing. Horses will rear in various circumstances. In this particular case, the specific circumstance of the horse rearing was due to either A, napping, resisting going forwards, that's the disobedience, B, napping because the horse was in pain. Rearing was in the normal parameters of equine behaviour in particular circumstances. Now, we know from the judgment, we know from the evidence in this case generally, that napping and disobedience are used interchangeably. And so that is the defendant's expert agreed. There was no cross-examination of that expert. That was accepted, that she is giving two versions. And she is saying the cause of this is napping, i.e. disobedience, because the horse is in pain.
Well, she doesn't use the word disobedience. She says napping, and that, as I understand it, and I'm with my lord on this one, I'm not quite sure about any of these expressions or phrases, but as I understand it, napping means not going forwards, going sideways or going backwards or whatever.
Yes.
So that's not necessarily disobedience, is it? If there's something in the way of a horse and it naps,
well,
that's not disobedience.
Well, I submit it is. If you're not going forward in accordance to instructions and you're going sideways and you're asked to go forward, you're being disobedient. And if we look at what the judge said about that at paragraph 29 of his judgment.
29.
Sorry, paragraph page 43.
Yeah.
He talks about the first, this was simply an instance of disobedience or napping, and I submit that brackets, the reading of that is he's using them interchangeably.
Sorry, which paragraph?
Paragraph 29. I've been
29.
presented
I've
with
been
two
presented
alternative
with
explanations.
Yeah.
And
This
then,
was simply an instance of disobedience or napping.
yes.
So you're saying that...
The way he's put that, I submit he's using them interchangeably. And if
I
we,
see.
And if we look generally at napping, there are a number of occasions where napping and disobedience are used
I think this
interchangeably.
might be a distraction, which is not going to help anybody, is it? Because if you read the rest of the judgment in context, the judge sets out your primary case and alternative case in 30, the defendant's case in 31.
Yes, but the what I'm submitting there is that if you accept that napping and disobedience are used interchangeably, and the evidence that this judge had, agreed evidence from the defendant's own expert, was that napping was the trigger on either version, it's my submission that that is the finding that he should have made if he didn't make it.
But napping wasn't the trigger. You can't read that bit of the expert evidence. Napping wasn't the trigger. The catastrophic injury was the trigger.
And if you actually read A and B, napping dash resisting going forwards, or napping because the horse was in pain. So the horse in pain is the trigger.
Okay, well if we take that example, or take that horse in pain, then I submit that a horse in pain is sufficient, and you do not need to know why it is in pain. It could be in pain because it's been stung by a bee. It could be in pain because it's trodden on something. It could be in pain because it's having a catastrophic internal injury. That, therefore, would be your characteristic. The horse is in pain. Sorry, your circumstance, the horse is in pain. Now, I have to concede that I'm on slightly trickier ground with pain than I am with disobedience or panic, which we haven't looked at. Because if you look at the transcript of what the defendant said about knowledge, we can find that at page 299 of the supplementary bundle. Now, before we get to this, it must be remembered that, of course, the deputy judge didn't actually refer knowledge to what the defendant had said. He used the expert evidence in relation to knowledge. But just looking at what the respondent did say, it's at page 299, my cross-examination of the respondent. You'll see that between C and D, when I set out the potential theories as to what has happened, the deputy judge at that time was concerned that I was going into expert evidence. And then I say I'll pursue it at E in a different way. And I say this: you've been a rider all your life, says in your witness statement, and you know that all horses can rear, even placid ones, if they are so triggered to do so. That's my question. And he says, I'm well aware of it, and have suffered from a number of accidents. Now, you know my primary case, that's sufficient. Now, I appreciate that we're beyond that now. So I then say, and the reason why they can rear is disobedience. Yes. And I say it could be pain. He says, I've not professional experience of a horse rearing in pain, no. But a reaction to pain could cause a rear. I'm no expert, so I'm not an expert to say whether it could or couldn't. And if a horse panics, it can rear, yes. I'm not asking for an expert opinion. I start talking about a horse reacting violently to pain. And he says, definitely yes.
Well, that's in relation to a horse kicking somebody who's branding it.
Yes, but the point I'm making is the violent reaction to pain is what we get at. And then the deputy judge interrupted me and didn't let the witness answer the next question about sudden pain and arrear. Now, I submit that admission that horses can react violently to pain would also be sufficient for me to get over the hurdle. So if your lady's position, well, it's pain that causes this rear, I submit I have enough in those paragraphs there to get home on that basis.
Was that a case advanced below?
Yes.
Pain. Mere pain.
I have to remind myself of my submissions, but the submission,
All right.
the submission made below was, as my lady put it, we win on any basis. This is a characteristic not normally found in particular circumstances, whether it's been triggered by pain, whether it's been triggered by disobedience, whether it's been triggered by a heart attack, is by the by. It's been triggered, and therefore section 22b is made out. And all you need to know for section 22c is that horses rear when they're triggered to do so. That was the thrust of the submission below. There is a final ground of appeal which is based on the facts in which the deputy judge, whilst giving permission, did say he didn't feel this was one that had a particular prospect of success. And that ground was, I think, ground 6, where we submit that, in fact, on the evidence this deputy judge had, he should have found that the respondent did have the requisite knowledge that when horses have catastrophic internal injuries, they may rear. And I did that, if I go back to the judgment. Page 56, please, paragraph 76. There, the deputy judge set out his reasoning as to why he did not feel the respondent had the requisite knowledge. He didn't base that on any of the cross-examination we've just looked at. He based it on what the experts said. And the expert joint evidence was this: we agree that as horsemen, we are unfamiliar with catastrophic internal injury causing a horse to rear either at all or rear to a height where it falls over backwards. And he took that as being evidence that neither would the respondent have that knowledge. But the experts went on, that is because we have not known this to be a cause of a horse rearing. In theory, however, as horsemen, we agree napping and rearing might be caused by such an incident. My submission is that second part of that evidence is important.
What, in theory? Is that the second
theory
part that you're referring
Yes.
to? The third sentence. So, in theory, however. So, on that basis, whenever a medical expert, in answer to cross-examination, says, well, theoretically that's possible, but on the facts of this case.
Well, the way I put my case in relation to this is this. What they say is we haven't seen this happen before. Mm. That is no different to the Welsh and Stokes position, as in we didn't know this horse did this. We know horses in general might, we didn't know this horse would do it. That is specific knowledge. It's the general knowledge we're aiming at, according to Welsh and Stokes. And so when those experts, as horsemen, not as experts, but as horsemen, say we know that in theory it could happen, I submit that is sufficient knowledge for the respondent as a horseman.
It's not. How can that be, Mr. Mooney? It's saying in theory. They're not putting any aspect of probability on that. It's in theory. They're not saying more probably than not. We agree that napping and rearing might be caused by such an incident. It's just that we've never seen such an incident before. It's not what they're saying.
But they're saying that in theory, napping and rearing might well be caused by an internal catastrophic event. And in theory, in my submission, that is sufficient.
In theory and might. So the judge has then got to make an evaluation on the balance of probabilities.
Yeah, and I accept that. But then
So that's an evidential basis. The
It
judge
is.
made his decision on a factual basis.
and that combined with the evidence that the detectives relied on at first instance from other witnesses who witnessed the incident and thought the horse was having a heart attack, I submit is sufficient that he was wrong in that finding. But I'll leave that there.
Okay. We'll go to your Scallison argument on that point.
I'm grateful. May I turn back for one moment?
Yes, of course.
Might as well. I'll try not to trouble for you too much longer, but just two more points, if I may.
Of course.
Firstly, I have tried dealing with disobedience
Yeah.
in my submissions. Of course, when the judge set out those potential alternatives at paragraph 29, he said this. He sets out the version that the appellant was, or the claimant was asking for at that time, rearing as a result of disobedience, and then says this: the alternative is some sort of catastrophic internal medical event described in layman's terms, though misleading, as a heart attack, causing severe pain or at least some awareness on the part of Tommy that something was wrong. This led him to panic and rear. Now, I submit that whilst he doesn't return to panic when he then goes to look at the when he makes his findings, the fact he set that out as the alternative means that it is implicit that he made a finding of panic when he prefers that second suggestion.
And so,
If he found that panic was the cause of the rear, which I suggest he does on that construction of that paragraph, we know from page 299 again that when asked in evidence, do you accept horses will rear when they're panicking, the respondent accepted that he did. So if you're with me that paragraph 29 means the learned judge found the horse panicked, albeit as a result of a heart attack or internal catastrophic event, the circumstance is the panic that leads to the rear, and that is known by the respondent. Why the horse panicked, again, at the risk of repeating myself, is to some extent irrelevant. Whether it panics because of the loud noise, whether it panics because of the bee sting, whether it panics for any other reason, or whether it panics because it's having a severe internal injury, to some extent is irrelevant. What matters is that panic led to rear, and that, I submit, paragraph 29 is the basis for saying that is the basis for his finding, and on the basis that the respondent accepted in cross-examination that he knew panic led to rear, that is sufficient to make out the act.
Well, in paragraph 29, he's putting forward your case, isn't it?
He puts forward my case originally, and then the alternative, so the defendant's case, is some sort of catastrophic internal medical event described in layman's terms, although misleading, as a heart attack. So that's the defendant's case.
Oh,
This
yes, I
led
see.
him to panic and rear.
Because if we look at then at paragraph 31.
Yes.
So that's point one.
On reflection, I'm not sure point 2 takes me very much further. So
Right.
those are my submissions.
Thank you very much, Mr. Mooney. Are you going to follow at all, Miss Hibbard?
No, no, lady.
All right. Mr. Norris.
Well, just to pick up the branding example we looked at a moment ago, you may not be surprised if a horse rears as a reaction to being branded.
Well,
What-
actually, the example given was a horse horse kicking out
Yes.
rather than rearing.
But I characterise it as rearing to make it particularly here. But what you know is that it's being branded. And that's the key particular circumstance in that example. What I'll do, if I may, and hopefully it's helpful to the court, is take this relatively shortly. I'll begin with some general observations about what the judge found as to fact and principle, to show how, with respect, he correctly applied Section 2.2. Demonstrate, I hope, that Section 2.2 actually works and makes sense in all its component parts, including particularly subparagraph C. And to also demonstrate that it works when one looks at the cases and indeed at the Law Commission's objectives as they're recorded in those cases. But the short point is that the judge did here need to decide what were the particular circumstances in which the characteristic of rearing were demonstrated, had to decide whether they were, in the language of the cases, predictable or foreseeable, and whether the reaction was, and the choice that the judge with respect had to make was between disobedience, which I would prefer to characterise perhaps as willful misbehaviour,
Right.
on the one hand, and a medical event of some sort on the other. And with that brief introduction, can I pick up what we say the judge essentially had to decide about the circumstances in which the characteristic of rearing arose? But you were kind enough earlier on to characterise the concession in our skeleton as being my concession. I'm afraid I can't take all the credit for it, because actually it's exactly what Miss Crawford conceded in the course of submissions below. It's always been our case, and if you want the reference to where Miss Crawford again conceded that we would be in difficulty if this were a disobedience case, as we would, it's at page 372 in the transcript.
Yeah, well, I think that
You may take it.
you very rightly give Miss Crawford credit, and we recognise that.
But just explain to me the basis of the concession by reference to disobedience, and I think you're saying willful disobedience.
Willful
here.
misbehaviour.
Willful misbehaviour. So how do you make that? How do you make the concession? Ignore section 5.2. So that's not it. So that defence is not made out. You say A is made out, Y is B made out, and Y is C made out.
Right. B is made out because you know that in certain circumstances a horse may react by rearing. This horse may not be a habitual rearer, like a dog may not be an habitual biter. That's what Lord Nichols in Mervahidi refers to as the first limb of B.
Yeah.
But it may be, and you need to know that it may be or is, a rearer in some circumstances. C is made out because you know that a disobedient horse may react by rearing in the course of what I've called disobedience, but I would perhaps more accurately called willful misbehaviour. The horse is deliberately deciding to do something contrary to that which it's being asked to do.
Why B is made out because you know that in certain circumstances a horse may
rear through disobedience. That's what horsemen know.
Right.
And so that engages C, because you know of the particular. You would not, let me take your disobedience. Let's take our disobedience example. If you know that a horse, first of all, if the horse has behaved in this way through disobedience, you know that it may do that, and you know that disobedience may occur. You may not then need to know the particular cause, the particular trigger for the disobedience. We're characterising this as willful misbehaviour. So if it's disobedient because it doesn't like walking past pigs, as some horses might not, even if it's the first time. You do know that this horse is capable of misbehaving as a disobedient response. It may not want to go past a red car. So you may not specifically need to foresee that it will react in this way to pigs or react in this way to...
Why rhetorically, do you need to know the particular cause of the panic?
Well, I'm going to come to panic, but this isn't panic. Panic is actually the claimant's case on its pleadings. What he's just read to you from paragraph 29 of the judgment and paragraph 31 is his characterisation of our case, not ours. So, in fact, we didn't ever say it was panic. It's a pain reaction, but that cannot be equated with panic.
Right. So you'll take... So there
but I will come back
to that. No, please do.
I will come back to what's called panic in a moment, but this is not panic to be equated with disobedience. Disobedience is, we're talking about willful misbehaviour here.
And so was the judge right or wrong at 75?
Well, he's right, but I perhaps slightly finessed the language. But he's correctly there approaching it as disobedience as willful behaviour. So his choice is between disobedience as willful behaviour and reaction to a medical event. The one is foreseeable.
He's saying
the other is
that
not.
You shouldn't. Isn't he saying if on your case it was willful misbehaviour, that would not be sufficient? It would not have been enough for the claimant simply to prove that the horse reared, and that is something which horses do from time to time. For example, whether they are startled or in pain or simply being disobedient.
Yes, he's looking at the claimant's case there, I think. But I take your ladyship's point.
But was he wrong? Is he wrong there by reference to your concession?
Well, he would be wrong if that were a characterisation of my case. But I read that as being a characterisation of how the claimant has put it.
Well, I find that's a bit difficult, isn't it?
Well, I see what you mean.
It seems to me that, I mean, it may not be fatal to your case, but if you think he was wrong here, feel free to say so from my point of view anyway.
Well, if you read it in that way, then he is wrong there.
Right.
Because as Ms. Crawford conceded, as I concede in the skeleton, if what happened here was misbehaviour in the sense of disobedience, a horse that doesn't want to go past something because it doesn't like the look of the pigs, to use the example I gave a moment ago, you know horses can be disobedient. If disobedience causes them to rear, as you foresee it may, then the necessary ingredients of B and C are both made out.
So in those circumstances, you say you wouldn't have to say it's the red car or it's the pigs
No.
that are known by the keeper or a member of his household to cause the rearing. It's the fact that the horse is disobedient.
Yes.
For whatever reason.
For whatever reason.
Yes.
So to use it... Sorry.
I was just going to go on to say, but Mr. Mooney then says, well, why should somebody be able to say, well, this is a horse who's disobedient for any number of reasons? It could be red cars, it could be pigs, it could be the noise of a rattle or whatever, crying baby. And yet here we have a case where a horse, there's more knowledge about this horse than many others who rear, and all of a sudden...
You're worse off.
Yeah, right.
Well, I didn't catch...
Well, you're worse off. The more you know, the worse off you are.
Well, that may be right. The fact here, you have to decide between the two events. What is the trigger, to use the expression we used earlier on? If it's disobedience, you know about that. To use the language of the cases, you take the risk by having the horse, by letting someone else ride it. You can foresee the circumstances arising under subparagraph C.
So you wouldn't agree with Mr. Mooney's concession that if somebody had recently bought a horse that was an habitual rearer, then they've got a defence? Because it seems to me that, in fact, you're stuck.
The habitual rearer is the first limb of B.
Yeah. But in any event, a horse rears. That's the whole issue here, isn't it?
Well, here, horses can rear, but it's not a habitual rear of B.
No, it's particular circumstances because of being
Right.
frightened, startled.
So Mr. Mooney might be right to say that if you actually have a horse that turns out to be an habitual rearer, and then if you didn't know any of that, you might possibly.
But you'll escape the first limb, but the second limb, every horse.
Because you know horses rear.
Yes. So one way or another, you're caught, aren't
Yes,
you?
but then the argument is, well, in what circumstances did this habitual rearer?
No. Forget about the habitual rearer. So as you say, if it's an habitual rearer, then you've got the first limb to consider. But suppose you then say, well, actually, the keeper didn't know at the time he bought this horse that it was an habitual rearer and that its mother was a circus performer and all the rest of it. But that doesn't obviate the necessity to consider the second limb of subsection B, which is that horses rear in certain circumstances.
Yeah.
And therefore, thinking about the second circumstance, the fact that somebody who had previously owned horses had just bought the horse isn't going to provide a defence, is it?
Well, if it turns out to be an habitual rearer, it's not just doing it in particular circumstances. That's why his concession.
If the court has said, look, all right, it's an habitual rearer, and on that basis, the new keeper didn't know that this was going to happen. However, quite apart from the fact that this horse likes to rear, it appears that horses have a characteristic in certain circumstances that they do rear when they're startled. And therefore, Mr. Mooney may go on to say, if we got a case where the judge said, this wasn't an habitual, look at me, I'm showing off rearing, but this was it could have happened for any reason, the fact that it was only just a recent purchase isn't going to help anybody, is it?
Well, I fortunately, in the case of not having to defend an habitual rearer,
No, good.
This horse had only reared once or twice in its life. There's evidence about what its history was. The horse equestrian experts, Mr. Taylor and Mr. Lane, agreed that this horse might have reared before, but that didn't mean that it was an habitual rearer, as that example. So this necessarily became a second limb of subparagraph B case, rearing in particular circumstances, and whether those circumstances and that reaction were predictable.
Yeah.
And that required the judge to make an investigation into and a choice between two possible causes which were canvassed. Rearing through disobedience, willful misbehaviour, that was predictable because horses can do it when they decide to react adversely to the instructions they're being given.
To an external stimulus.
To an external stimulus.
Yes.
Here, by contrast, it was an unforeseeable event, or at least unforeseeable by horsemen, as the experts rather strangely. And it's that makes subsection C in this context work and provide what we say is the complete defence. So that's how the whole provision works. I can develop that a little further and look at the cases to
I'm
show
sure
that
you
that
will,
right.
but I just, this point that Mr. Mooney makes is not something that we can just brush under the carpet with respect. He's saying it would suit a claimant to have a judge find that it is a general characteristic of a horse to rear in certain circumstances, and therefore it follows that because this horse that was not an habitual rearer did rear, there was something that spooked him, startled him, upset him, an external stimulus that did this. And just suppose for an example, Tommy had a spasm, a gut spasm, and he'd reared for that reason, but had carried on trotting down the road into the hunt, and nobody was any the wiser, then he would have come to court and said, well, there was some reason for the horse to spook. In this case, unfortunately, Tommy died, and the expert opinion, because there was no post-mortem, is that it looks as though it was a heart attack, and it wasn't just the expert opinion. There were other people with experience who said, I've seen a horse having a heart attack, and that's what it looked like to me. So this issue of, you know, the less you know, the better for the claimant on the basis of what you're putting forward. I'm not saying it's right or wrong, I'm just seeing how you answer it.
To use your example there, the horse has a gut spasm and then continues working.
Well, rears.
Rears
the
when it's
rider.
had gut spasm. So
Yes, but then trots off.
You then may have some insight into it having a medical condition, and as
But
to
suppose you don't, because the horse recovers quickly after its colic or whatever you'd call it.
But you have at that stage seen that the horse has really, on your example, if I'm to assume that I've no idea the horse even then has got a gut spasm that's causing it, that then we're absolutely in exactly the same position as was the case with Tommy here. So
No, because here Tommy died, and there was expert opinion that there was two possible main front runners. One was the heart attack, one was the brain injury caused by a whiplash.
yes.
But if you'd got I've been very careful to say external stimulus causing the disobedience, red car, pigs, bee, whatever, and the internal stimulus, that's colic, gut spasm, whatever horses have, I don't know, I'm sorry, but something that causes the horse to rear but doesn't kill it, and it's not apparent from any wound or anything externally, but then, having thrown its rider, the horse trots on.
And no one ever finds out what
And
it's
nobody ever finds
cause
out
was.
why. Now, Mr. Mooney would say, well, on those circumstances, we'd be in a position of saying this horse, not being an habitual rearer, reared for some reason.
That's
and
the
it's-
probability.
Yes, the probability is an external stimulus. So why, he says, should that be any different in interpreting this section than something that then becomes known? And it's his point.
Because here we know better.
Right, okay.
It's as simple as that. Here we know what the facts are. In your example, we wouldn't know. And we decide matters on a balance of probabilities, and if there had never been any hint of any internal injury, any interior event, to use your characterisation.
And I mean, the cases are replete with statements to the effect that it's a matter of evidence in each case, and of course it's not something that's wholly within the gift of the claimant, because a defendant can meet a claim by saying, well, you may not have any particular circumstances to advance, but we do. So Ms. Ford says, I've got no idea what happened, something must have happened, to cause the horse to rear, but can't help you with that. And you may or may not be in a position to counter that, but with evidence, as you did here, to the effect that actually it was an internal heart attack and not willful disobedience.
Quite, and sometimes it works the other way. So the claimant was in difficulties in the Freeman case in being unable to demonstrate that the fact that the horse bucked when going into a canter, what was the cause and foreseeable circumstance here, because there wasn't enough evidence about how horses behave when first going into a canter.
Am I right that on all of the authorities where the claim has succeeded, there has always been a finding that something else was involved?
You're absolutely right. So let's just pick those up and take them in order, if I may. There's always an event.
Yes.
So in Mervahidi, something or someone, those are the words actually of Lord Scott dissented, something or someone frightened the horses, causing them to flee in blind panic, disregarding all obstacles. See Lord Hobhouse.
So it wasn't just panic, it was...
Quite.
So at each stage, it's my recollection, is that it's not just the alarm, fear, distress, it's the thing that triggered the alarm, fear, distress.
It's event and reaction. Reaction is panic, but the event is identified, and those are the particular circumstances foreseeable under
Because it's
B.
interesting, isn't it?
So under C.
We haven't concentrated on the word time. It's time or circumstance.
Yes,
Sorry,
I agree.
I'm
No,
just pausing to think out loud.
I agree. Which is why, even if it had been our case that this was panic enough, it is only dealing with one part of the Mervyn-Heady analysis. It's the reaction to the foreseeable. What was foreseeable in Mervyn-Heady was that there would be some sort of frightening, some sort of external event, whether it was a person or something that caused them to be frightened. Some general kind of cause, taking my disobedience example of red car or pigs, something was, but what it was precisely didn't matter, but some sort of event was foreseeable. That's Mervyn-Heady. In Welsh and Stokes, again, you don't just have a horse rearing, and the particular circumstances there, known to the keeper, was that it was a young and inexperienced rider trying to control the horse.
So that's the rider, not the horse.
Those are the circumstances. So you're looking at both.
Right.
I mean, there weren't any riders in Mervyn-Heady. The horses are on their own. So you're looking at the circumstances of the reaction.
So in Welsh, the trigger is somebody didn't know what they were doing.
Yes, but he's trying to control the horse. In Goldsmith, the horse reared, bucked, and actually kicked the claimant in the face when startled or alarmed by something. So that's just pure Mervyn-Heady.
Sorry, but startled or alarmed by something.
By something, but exactly what was never identified. So that's just Mervyn-Heady. In Turnbull, the horse was being ridden in a bitless bridle with which it was unfamiliar. So it's predictable that it might react adversely to that. And in Freeman, as I said a moment ago, the circumstances in issue were bucking when starting to canter, but there was no evidence about that, so the claimant failed on that basis. Anyway,
you say pure Mervyn-Heady, and you no doubt know what you mean by that, but can you help me with what you mean by pure Mervyn-Heady?
Sorry, that was rather careless. What I mean is a frightening event of some sort, although the particular kind of frightening event, external fright, startling, alarming in Mervyn-Heady, was not identified. So something startled or alarmed in the if in the hope that it's helpful, what I have done, what we have done, looking at the cases, to make the note-taking digestible, we provided a speaking note, tabulated paragraph by paragraph. This is the point. Would it be helpful if I just hand that in and you can look at it at your leisure?
When you say you've done that, presumably Mr. Mooney hasn't seen it.
He hasn't. He knows I said I would do it. But I mean, I could take it through paragraph by paragraph as an oral submission. It's just actually intended to be a speaking note. But if it's not helpful, I won't probably.
Well, I don't know if it's going to be helpful or not. You're talking about speaking note as to the authorities.
Yes, just that.
Yes. Fine. Mr. Mooney, do you want to say anything about that?
As
long as you have a copy as well. Yeah. Thank you, Mr. Norris.
I'll come to it in a minute, but it just saves. I'll explain what I've done. Thank you so much.
And this
Actually,
is
I'll
just
do yours.
this is a speaking note, not a skeleton argument.
Well, I'm calling it a speaking note, but it's intended to be helpful. If you don't think it's helpful or think it's burdensome,
well, let's look at it
or unfair,
and have a go. Because as you know, there's an application to put in a supplementary skeleton argument, which was not back.
Yeah, no, that's fine. I'm not wedded to this. I'm merely just trying to help the court. If you see what we've done here.
Oh, so it's a case law analysis.
Correct.
Yeah.
And just to explain what I've written, in case it's not self-evident, the tabulation on the right, if it's not in italics, it's intended to be just purely factual. If there's any commentary, it's italicized. But it just may help if when we come to the authorities, which okay. I will. But if it's regarded as an impertinence because it's a further skeleton argument, then I'm very happy to put on one side. It's just meant to be helpful.
All right.
Um,
So we've got to a frightening event.
we've got to a
Something
frightening
was
event.
not identified.
It would just
Pure
be.
morbid.
It would be helpful at this stage if I just come to what the judge found, if I may.
Yes.
Go back to the particular case. Paragraph 46 at page 48. Where the judge canvasses the opportunities, and we've looked at this already.
So this is his actual finding as opposed to his recitation of the competing arguments.
Exactly so. And go back to the question you asked me earlier on about panic. This is his actual finding. He doesn't use the noun panic, and we would submit it wouldn't be apt anyway, but this is his finding, and this, as you'll read to yourselves, is the choice between the two alternatives. And having done so, the judge picks matters up, as we saw earlier on in paragraph 75. We already looked at paragraph 75, I'm not going to turn to it again, but I would ask you to look at paragraph 76 and 77.
So he was treating it in that simple way, as it were. It was the reaction was to a catastrophic internal injury.
Exactly. And it might be helpful if the court pleases just to see what the equestrian liability experts said about that. If you go to the supplementary bundle, in my case it's behind tab 9, but it's page 182 and following. Being their joint statement, particularly draws the court's attention, paragraph 2 and 6.
Why 6?
Just because in passing, I was talking earlier on about his behaviour in the past. And then the key findings are over the page on page 185 at paragraphs 11 through to 16. Sorry, through to 15. Which is why at paragraph 77 of the judgment, the judge's conclusion is, if I may say so, clearly right, and that is sufficient to dispose of the 6th ground of appeal, which is the one that you remind me I tried to put in a short supplementary skeleton. The 6th ground, core bundle, page 11, is the judge was wrong to find the defendant didn't know that horses might rear when suffering a heart attack. But then, friends, already drawn to your attention the passages in the evidence where Mr. Seymour-Williams was cross-examined about this, I needn't go back to those. And otherwise, the knowledge that a horseman would have is sufficiently covered by what the experts say. So just drawing those threads together, that's why we say that the catastrophic medical event wasn't foreseeable. If it had been, then you wouldn't probably have needed to know precisely what the medical event was. So even if it was if you foreseen that a horse might rear in response to a respiratory ailment.
So and forgive me for picking you up on this, but why are we talking about reasonably foreseeable?
Predictability.
Because Section C talks about knowledge.
Because in the case law analysis that
Yes.
we've done, predictability is key.
Thank you. Just give me the reference for that.
So,
what knowledge means reasonably foreseeable.
yeah. So if you've got my can I just give you the passages in the table?
Yes.
So if you go to Lord Nichols at paragraph 21.
Mervahidi.
I beg your pardon.
Yes.
In Mervahidi, yes. Go to Lord Hobhouse at paragraph
Sorry, 21.
Page 21. In paragraphs 34 to 38 of Lord Nichols.
Sorry, so page reference 21.
In the bundle is page reference
Yeah.
21. And
I don't see predictability there.
No, you will though. I'm coming to that.
Right.
I'm just going to give I'll give you all the references to foreseeability and predictability, if I may, if that's helpful. So you have page 21, and Lord Nichols' reference to behaving characteristic of species and circumstances. Lord Hobhouse, 62, 63. The defendants knew their horses would display these characteristics if seriously frightened. If you go to Lord Walker at page 46, paragraph 138, reference to internal stimuli, which can be expected. So that's, I'm saying there, the same expectations, the same as predictability. Then to Lord Walker, page 47, paragraph 139.
I understand that predictability is one of the indicia of characteristic behaviour, but is there anywhere that says that knowledge in subsection C means reasonable foreseeability?
Well, I'm equating it with that in these particular examples. So if you go to Lord Walker at page 51, paragraph 156, talking about Parliament's intention, animals known to present special dangers.
Well, that's what I'm trying to say.
Yeah.
Well, not trying to say, but I mean, right.
Can I then go on to Welsh and Stokes, if I may, please?
Well, do you want us to look at
Welsh and Stokes?
paragraph 157 in terms of knowledge as well?
Yes, sorry, did I not include that?
No.
I should have done. Well, I didn't
You went
note.
to 139. I think 157 is probably better.
Yes, probably.
Which does talk about knowledge.
It does.
I think.
And then it talks about propensity, which I characterise as similar to predictability in 161. If you go on to Welsh and Stokes.
Sorry. C needs to show the damage was caused by the characteristics which are capable of handling. In short, a frightened horse's propensity to bolt. I understand how propensity can play a role in B, but I can't understand how it plays a role in C, which talks of knowledge. That's my simple point.
Well, then Lord Dyson, or Lord Justice Dyson, as he then was in Welsh and Stokes,
Yes.
is helpful.
Yes.
If you go to the paragraphs I've included there.
70 to 71?
No, I'm talking about 46 to 47. Oh, sorry, I beg your pardon. Well, 68 to 72 in the pages, paragraphs 46 to 47 and 61, where we would submit Lord Justice Dyson provides a very helpful explanation of the interrelation of B and C, because B won't succeed unless the knowledge requirement
I
in
understand,
subsection.
but again, knowledge in subsection C. Is there anything in the authorities that suggests that the test in C is reasonable foreseeability as opposed to knowledge?
Well, it must be actual knowledge.
Right.
So
Well, it's 70-71 then, isn't it?
yeah,
No
Lord Dyson,
requirement.
Lord Justice Dyson, 1771 is talking about needs to be actual, not constructive knowledge.
Yes. So it is actual knowledge, not reasonable foreseeability in subsection C.
It's foreseeability of the behaviour. It's actual knowledge that would lead you to foresee that a horse would rear in that way. So you need to know both that the horse, in this case, has the medical condition, or to be able to foresee that it has that knowledge, and to know that it will react in that particular way. But it is actual knowledge, not constructive knowledge. And then if you go to Freeman, and what Lord Justice Etherton there, he uses the words times or circumstances which can be described or predicted.
Yes.
See paragraph 43.
Yes, my point's a very narrow one. It's simply to make sure that knowledge in C means actual knowledge.
It does mean actual knowledge. But there, paragraph 43, Lord Justice Etherton, times or circumstances that can be described or predicted. And when we looked at Turnbull, the example we were earlier on, Lord Justice Jackson's wolf and sheep's clothing example, again, you know you're keeping wolf and sheep's clothing. So, sorry, that was the example, I beg your pardon, not in Turnbull, that was in Freeman. If we go on to, right, it was in Freeman. If we go on to Turnbull, lastly, Justice Morris Kay deals with knowledge and likelihood. And Lord Justice Lewis expresses a reservation which I don't raise here, but if this case ever were to go to the Supreme Court, it might arise as to how subparagraph A works in terms of severity of injury, because unless you're going to say that a horse may rear, someone may fall off, that automatically makes it likely possible that someone will suffer severe injury. We've conceded it thus far because on the authorities we were bound to. But in the Supreme Court it would be open to say that actually not every rear or buck is going to be likely to cause severe injury.
No, in this case, though, the horse did.
Fell on.
Yes.
It doesn't arise on this
shall
case.
we get on with this appeal?
Well, we've got
For
on.
us.
We've
Yeah.
got it. But I just, since we were looking at that Turnbull example, I just wanted to, as it were, express that reservation. But what I said I'd do is just probably do this within the time allowed. I said I'd just look particularly at the isn't this just panic example to explain why the claimant doesn't get around the choice the judge had to make between medical event and behavioural misbehaviour, behavioural reaction, disobedience. Really for three reasons. First of all, as I said earlier on, it wasn't actually the defendant's case that the horse's reaction to the cardiovascular event could be characterised as panic. I know that's how the judgment reads at paragraphs 29 and 31 we looked at. But actually that was the way the claimant put our case in the amended pleading. If you look in the core bundle, at page 65. Claimant by amendment was the one who averred 5 lines from the top of the page in the amendment to little b. Tommy reared in circumstances of pain or panic. So it actually wasn't our case that this was a panic reaction. And the second of my 3 points is that the judge didn't find it was a panic reaction. It was a physical reaction to something unusual happening. That's what he found at paragraphs 76 and 77 and 46, which we also saw how the horse experts had agreed. It's actually what the vets had also agreed. If you just kind enough in the supplementary bundle behind tab 10, page 187. What the veterinary experts agree is best seen in paragraphs 12 and 16. What the horse experts said we saw in paragraph 12 at page 185 in their joint statement. And the third...
Sorry, so I'm not following that. So what 16 says could have been just perception of something bad, could have been painful stimulus. 11 says, 12 says could have been a reaction to something
bad is happening.
Pain, right?
16, what is this characterisation of panic comes entirely from the claimant. It isn't.
I see. So that's
the point.
Yep.
It isn't. So I'm just saying you can't just say panic equals fright. There you are. I've established fright. It's a reaction. But in any case, even if you call the reaction panic for these purposes, my third point is that that's not enough, because subparagraph C in context requires the keeper to foresee that in the context of the event that has caused the reaction. And that takes us back to the choice we made earlier between medical event, not predictable, disobedience, willful misbehaviour, predictable.
Sorry, I thought it was the rearing because of the medical event that was not predictable.
Both. So you can't. You need to identify both. I mean, you can't really identify one without the other.
Yes, you can. You can simply say if there is a heart attack or some sort of catastrophic internal injury, is it foreseeable that the court? Do you know that it is possible, likely that the horse will rear? That was the question for the judge, and he said on the facts, no.
He said no on the facts. Correct.
That's the strict.
But the claimant needs to prove both elements of that. Is what I'm saying. Is he needs to prove that not only the particular event he's proved. In this case, he'd be proving the medical event. You need then to prove that it would be foreseeable there would be a reaction to it. So that's why I said it was both elements.
Well,
not a reaction, will be a rearing.
Yes.
I was going to say, there is a reaction to it. If the horse dropped dead, that's a reaction to the heart attack.
It
so
is.
It's the rearing.
It's the rearing.
Yes.
That's, I mean, the particular reaction. And as I say, what the judge found, with respect, the judge was bound to find. It just might be helpful in the same context just to look at what witnesses themselves said. The claimant herself in her witness statement, which you have in the supplementary bundle, at page 88.
Well, it's only going to be useful to take us there if Mr. Mooney said that it was against the weight of the evidence, and so far he's concentrated on that part of the joint experts report, which is, in theory, however, as horsemen, we agree napping and rearing. I mean, we're not here to make findings of fact.
No,
We're
but
here
he
to
did
see whether
submit
or not the finding made by the judge was irrational or perverse.
he has said in ground 7 that that was a finding he shouldn't have made. And I was looking not only at what the equine behaviour experts and the vet said, I was just going to take you to what the claimant herself.
Well, I think he's got to do
said.
more than saying he shouldn't have found it. He's got to say there was no evidence upon which he could have made that finding.
Well, in that case, I needn't trouble you with
Well,
what.
unless my lady or my lord want to go any further with
No,
that.
it's in what Mr. Seymour-Williams said as well as.
Well, I'm speaking for myself, and I've read what the claimant said as part of the pre-reading. So
Well,
we have all the material in front of us, as it were.
if it's of any help, the references are pages 88 and pages 100. Claimant's evidence and Mr. Seymour-Williams' evidence when he was cross-examined, which you have looked at 299 and 300. That's as far as we need to take that. So, just to conclude, therefore, by just focusing on how Section 2.2 works in practice. 2.2a, as I said, was conceded here, damage likely to be severe. 2.2b has, as we said already, 2 parts, best explained by Lord Nichols and Merthyr Heady at paragraph 18. Dog that's the habitual biter comes under the first limb of B because dogs aren't, as a species, habitual biters. Second limb of B is when the victim is defending her pups. C is engaged when the particular circumstances are those that the keeper knows. As we've already seen here, this horse wasn't a regular or habitual rearer, as we know. We've seen that in the joint statement. So it had to be a case under the second limb of B, if at all. That's where the choice had to be made between the alternative hypotheses. Those hypotheses then engaged the court in the exercise under subparagraph C of deciding whether they were predictable. I said foreseeable, predictable is a better word, and it's one that I picked up and find in the cases anyway, and that I've already addressed. My lady, the handout was just intended to be helpful to avoid going through all the cases, but actually you've already pinned me down to what I say is the most important component of them, and that is that in each case, the courts make it clear it is necessary to identify the circumstances, and those circumstances need to be known to the keeper. And that in this context means knowing that a horse may rear as a reaction to a medical event as opposed to may rear as a reaction to misbehaviour, disobedience.
And you refer to a medical event as being an internal stimulus, not a...
I call that an internal stimulus, as you say, and that, as we respectfully submit, not only means that, for all that people have been so rude about subsection 2 in the past, actually it makes sense, and it achieves what the law committee's objectives were. My only friend gave you one example, but can I just flag up the others in my handout? So Lord Nichols talks about paragraph 17, paragraph 34 to 38.
You don't address paragraph 43 of Merthyr Heady.
No, you're quite right, and I
ask you to help me on that.
I have put on my note, in handwriting here, and forgive me for not having mentioned it.
So Mr. Mooney describes this as being a claimant-friendly interpretation of section 22B, which means basically it's extremely easy to satisfy.
Yeah, well, I should have included paragraph 43, but nothing that I have said needs to be qualified in the light of what Learned helpfully read from that section. Otherwise, there is another reference to the Law Commission, which, if you give me one moment, I will just tell you that. Just give me 1 second. Yeah, I think it is. I think it's also, I want to also flag up paragraph 70 Again?
Well, in paragraph 70, there is a quote from the Law Commission report, as far as any of this helps.
I think it does. As far as I'm sure I understand. But there's also quite a useful quote from Lord Walker talks about the intention of Parliament in my note at paragraph 156, page 51. Talk about the intention of Parliament being to impose strict liability only for animals known to present special dangers.
But can we go back to 43? What are you going to say about it?
Turn it back up. I will.
It's obviously not on this point, it's a separate point.
It is on a separate point, but
Mr. Mooney says that this shows that section 22B is claimant friendly and very easy to satisfy.
Before we go there, how much longer are you going to be?
I'm pretty much there.
All right. How long do you think you'll be in response, Mr. Mooney?
No longer than 10 minutes. No longer than 10 minutes.
All right. Do you want to press ahead? Press ahead?
Gee.
Can I just ask, if we press ahead, is that going to cause you any difficulty? You sure? Yeah, all right. I'm going to say this, Mr. Mooney and Mr. Norris. I don't want you to feel as though you're not able to make your arguments just because of timing, because we can come back at 2. But we will push on. But if it appears that you're both mistaken or over confident or ambitious, then we will return. But please don't feel that you're hamstrung by time. And that goes for you too, Mr. Norris. But let's go to paragraph 43 now of Merrowby.
Yes, the other reference I was wanting to give you to the Law Commission is in Lord Justice Stanley Burnton's reference.
Before we get there, my lady wants to deal with paragraph 43, and she asked first, as it were.
Paragraph 43, with respect, doesn't cause any difficulties at all. Except that I am not sure I necessarily agree that it isn't easy to conceive of circumstances where dangerous behaviour, which is characteristic of the species, won't satisfy requirement B, for the simple reason that this case now gives us a pretty good example of where it's not characteristic of the species. In this way, say if you just look at the rearing, which is characteristic of the species, but the particular circumstances are not. Then one goes on to say a normal but dangerous characteristic of the species will usually be identifiable by reference to particular times or particular circumstances. And so it is in this case, and the question under C is whether they are predictable, whether they are known. So to that extent, with respect...
I just don't... A normal but dangerous characteristic of a species will usually be identifiable. I see. So you can identify it because you can identify that what caused the rearing here was a heart attack.
Exactly.
But it's all about C.
Knowledge under C, whereas if it were disobedience, this would fall squarely under 43.
So it would fall squarely under...
Under paragraph 43, if it were disobedience, which is why we conceded that if it were disobedience, we would lose.
But then that would suggest that you agree that subsection B is normally easy to satisfy. But I suppose what you would say, it doesn't go to meet Mr. Mooney's submission, or rather doesn't support Mr. Mooney's submission, that you don't need to identify the particular time or circumstance.
Exactly so.
That's the point.
Our point in our skeleton is that if Mr. Mooney's right, you don't need to go beyond subparagraph B.
This actually doesn't say that you just ignore the time and circumstances.
Exactly
Just look
so.
at the rearing. Yeah.
Exactly so. So the other example I was trying to give you was Lord Justice Stanley Burns, and deals with the Law Commission. I think we have the objective clear enough in paragraph 17, which is quoted in Murvahidi.
I think it's quoted in several of the
It is quoted in several. I'm merely trying to complete your note, but those are my submissions. I have nothing to add beyond that. May I just chat with
Yes,
Ms.
please
Crawford
do.
in case there's anything to add?
You follow Miss Crawford?
No, thank you, my lady.
Thank you. So, Mr. Mooney, are you still willing and able to go now?
Lady, yes.
All right.
But I shouldn't detain you long at all. What is not clear from this judgment is what findings the learned judge made in relation to section 22b at all. I submit that in light of my learned friend's submissions, it is now clear that the judge was wrong, was erroneous in paragraph 75 and his way of looking at section 22b. Indeed, I submit that on what we have heard from both parties in this case, it is clear that subsection 22b must have been made out in this case. The judge said at paragraph 76, I found this was more than simple disobedience for some unknown reason. I'm not going to repeat my submissions about what more than simple disobedience means, but you have those. The horse is probably reacting to catastrophic internal injury. While that may be described as a particular circumstance, now, it's not entirely clear whether the deputy judge was saying, therefore, section 22b was made out, or whether he was saying it may have been made out. My submission must be that under any basis, section 22b was made out, because what you have there, that he's saying a particular circumstance is more than mere disobedience, it's catastrophic internal injury. So 22b is made out in this case, on my learned friend's case. This comes down to, on my learned friend's position, 22c. And the question for this, for your ladies and my lord, is this, I submit. Having satisfied ourselves that 22b is made out, how do we make out 22c? It is the appellant's submission that it is sufficient to say, I'm a horseman, I know that horses are in particular circumstances at particular times.
Can you say that again? I'm a horseman.
Yes, I know that horses rear at particular times and in particular circumstances. Therefore, when this horse does damage by rearing, I know that that might happen. And that is sufficient. And that, I submit, is consistent with the wording of the Act. You'll see in my skeleton argument, I say in Annex Ground 4, that the Act does not say, and you must also be aware of the particular circumstances. And this goes back to my argument on that section 22b is satisfied simply by proving it's a conditional characteristic, but I won't repeat those submissions. That is the first point. The second point in relation to 22c is, even if you're not with me, that generic knowledge that horses will rear in particular circumstances is enough. The second point is, well, what do you need to know? Well, you need to know the immediate trigger. I submit the evidence on this case, and I do pray and aid those paragraphs of the judgment that we've looked at, paragraph 29 and paragraph 31, where the judge particularly sets out panic led to rearing, albeit after heart attack. I submit that if you're against me on the generic nature of 22c, then the specific knowledge is horses rear when they are panicked and or being disobedient. And that is
being disobedient, right.
having spent so much time and energy trying to convince you of disobedience, I'm not going to abandon it now, my lady.
Sorry, I literally didn't hear you, Mr. Mooney. No more with that.
And in relation to that, I pray and aid the answers to my questions from the respondent at first instance.
Which you took us to.
Which I took you to. And also his acceptance that they would react unpredictably and in relation to being in pain.
But that's all in the section that you took us to.
Yes.
Yeah.
The final point, which I press only as far as you've seen it in my skeleton argument, is he made an illogical conclusion in light of the evidence that he heard. But I push that no further. Finally, I come to this. My learned friend spent, and there was much discussion with my learned friend in relation to knowledge and foreseeability. It is that point where I submit his submissions fall down, because this is an attempt to import foreseeability into a strict liability act. It is taking it out of the realms of strict liability and into the realms of negligence in the common law. And that is the problem with, in my assessment, of his analysis. I accept that the analysis that I urge upon my ladies and my lord may be seen as emptying 22C of content, but you've heard my submissions about that's only because 22B has been emptying content. But his submissions lead you down an even more unpleasant path. Unpleasant's the wrong word. Unfortunate path, because it empties the act of content. Finally, my lady asked my learned friend about paragraph 43 of Mervahidi, and my submission it was a claimant-friendly act as a result of the Mervahidi analysis. Of course, it's not just paragraph 43 of Mervahidi. It's not just Lord Nichols that has said this. In Goldsmith, Lord Justice Jackson says it at paragraphs 39 and 46, page 92 and 93.
So at 39 and 46.
And the words he says he can't see any purpose for section 22B. And in Turnbull, Lord Justice Morris Kay, paragraph 23, describes the drafting of subsection 22B has resulted in its virtual emasculation. So it's not just paragraph 43, it is a theme that runs through the authorities. And if you'll forgive me, the ill or the mischief that my learned friend's submissions try to stop have already happened as a result of Mervahidi. Forgive me, the horse has already bolted. So for all those reasons, I submit that the appeal is made good, particularly in relation to the points I made in relation to 22C about panic and disobedience. Is there anything else I can deal with?
I don't think so. Thank you very much indeed. Well, thank you for the submissions that you've made on this case. They're very interesting. We will reserve judgment, obviously, and we will hope to have the draft judgments with you as soon as possible. This gives you an opportunity to correct our English, if necessary, but not our reasoning. And you will be then asked implicitly to see if whether, dependent upon the judgments, you can come to a conclusion on the draft order to be submitted. If there are any further submissions to be made as to ancillary matters, at first instance, please in writing. Very much. Thank you very much. Thank you. Thank you.